This is the newest video today. It is titled, How to Spot a Broken Chain of Title in a Collection Case. With this video on my membership site, collectionstoppersolutions.com. Hey, how'd you like the digs? I'm doing it from a desk. Anyway, so along with the video of this will be a form that it will be in Word, and what I want you to do is type in the information I'm going to show you and have that be part of your answer. Have it be part of your counter affidavit. It should be jumping into your counter affidavit, but it's a way to collect. I always tell you, break down the lawsuit. We'll break down their paperwork and put it in this new form called a broken chain of title form. It'll be attached to my membership website with this video. At the end of this, or near the end, I'm going to give you a bonus letter to really screw up, in this case, velocity. So this form I'm going to give you, this explanation, is going to be for every debt buyer that attaches bills of sales and fake assignments and transfer documents that just don't mean anything or don't include anything. In this case, I'm using a real case against velocity to make my point. So Cindy, put up the first and second page of the complaint. Shazam ski. And again, I'm doing this from a different approach. Let me know if you like it. And you can see their paragraph 9, which, by the way, their paragraph 9 in the second page is the only thing that even mentions things being assigned. I think there's several more than 9 paragraphs. And you can see right off the get-go, that's a whole plate of wrong. They're saying on November 17th, the original creditors. There are no original creditors in my 30 years of doing this. There are no original creditors. By virtue of the fact that the word original starts off the word creditor means you can't have more than one. So why would they write original creditors? Because they've made such a mess of it. Actually, the people that sold the debt to Velocity, they have to sort of squeeze in these pieces that don't match by throwing in kind of fuzzy words. So in this case, as you know, in most Velocity cases, they're buying fintech loans that have been securitized out and transferred and broken up. Well, the debt buyer buys it, and now it's got this mess to deal with. It's pretzel litigation with an S. Original creditors do not exist, but they say it does. And the original creditors, they started this thing November 17th, 2022, when they, I guess, got the loan agreement. So the plaintiff is saying more than one creditor. The original creditors associated with this loan agreement and promissory note, there's only one. And that is FinWise Bank. In that loan agreement is a way to really trip Velocity or any debt buyer that buys this. And they say it right in the loan agreement, say, just do this. So I'm going to show you at the end, you're going to do this. I'm going to give you the letter to do this to really trip them up. Okay, so let's put up on the screen part of the loan agreement, Shazam. And that tells you, that's the approval disclosure. You can see right there, the word creditors doesn't exist. The creditors, FinWise Bank. In 2021, FinWise and my client got together and they borrowed, my client borrowed money and FinWise gave it to him. It's usually like that. You can also see the bill of sale. Let's put up the bill of sale, Cindy. I'm adjusting to this camera as opposed to the way I normally do things. And there you have, there's that magic date that you just heard about in paragraph 9. Cindy, put up paragraph 9 near the bill of sale. And you can see the bill of sale says something was sold to Velocity November 17th. So number one, that's why Velocity is stuck on this date. And you'll see how ridiculous that is. Somebody called, I'm reading this, Upstart Structured Pass-Through Trust Series 2022 1A sold something, maybe loans, well, that's what they call it, related receivables, charge-off loans, judgments, and evidences of debt. If you got something to sell, you say what it is. A 59 Chevy, a 61 Maytag refrigerator. You don't need to use flowery words, so they're hiding something. So November 17th, supposedly Velocity received something. All right, let's take a look. So that's what we call our Exhibit 1. And then the certificate of loan transfer document that attaches to every thousands of these Velocity lawsuits. Let's put that up. We call it Exhibit 3 in our notes. Shazam. And you can see there that FinWise Bank is selling loans to Upstart Network Inc. Why is that important? Because look at the date. Focus in on that, Cindy. 11/23/2022. Not possible, right? Because Velocity already bought everything in November 17th. So how does, now that's, FinWise is the original creditor. So only they can sell something to this Upstart structured pass-through or anybody else. And until they move it into the marketplace, nobody else has a piece of it. So that's their own document, by the way. It's Exhibit 3. It's telling you the original creditor, FinWise Bank, sold it or something to Upstart Network. We won't get into how they specifically don't mention my client. And what we will get into is now Velocity, to own this debt, has to have the new owner, which is called the current creditor. So after the original creditor, there are no original creditors. There's the original creditor, and this is how the law looks at it, the current creditor. That's a term of art that's used in law. So the current creditor at this point after November 23 is Upstart Network Inc., according to their own documents. We're using the documents against them. So the November 17th thing may be true, but two things are wrong with that. It isn't your client or my debt or your debt or anybody's debt that we care about for them to have standing, because nothing came off the original creditor until 6 days after this bill of sale. So you've knocked that out. Also, who gave whatever they gave to Upstart Structured Pass-Through Trust? There are no other creditors in the loan agreement, so only one creditor exists, and that is FinWise Bank, the original creditor. So who gave whatever they gave to Upstart Structured Pass-Through Trust November 17, 2022? There's no record of that. So until, again, FinWise puts this into the market 6 days later, they can't use this as of proof. And the date, by the way, November 17th, of proof that anything went their way. You have to have Upstart Network Inc. On the date of either November 23rd or a day after sending what they have to Velocity. That doesn't exist. So that will be incorporated in this form I gave you. So I'm going to put up, I'm going to have this great form for you to fill out with your facts. And I'm going to show you the cool thing you do with that. So, Cindy, put up the proof of the broken chain of title. Let's call it Jones versus Velocity, case 24-123-8899. Shazam, right? So you'll see, this is what went into my answer. Fact, FinWise Bank is the original creditor, Exhibit 1. Just quickly put up Exhibit 1, Cindy. That's your support. Never say it. Support it. So always have support for what you say, unlike your opponent, the plaintiff. Number 2, fact. The certificate of loan transfer attached to Exhibit B, that's Exhibit B of their documents, shows a November 23rd, 2022 sale. Fact. Plaintiff presents a bill of sale at their Exhibit B that's dated November 17th, 22. See the bill of sale, and let's just put the bill of sale up. Shazam real quickly, Cindy. Again, not sure if I'm pointing, I'm working with no screen. And there you can see November 17th, which is their date, but they don't get to say they sent or received anything until after November 23, as I explained earlier. So that's how you trip them up. You take their documents, their dates, and take this broken chain of title form that will be attached to my video and fill in the blanks the way I have. You see how I do it for like 3 I've got several paragraphs. They won't be the same as mine, but it might be if you get a velocity case, and there's tons of them. Just fill it out for your case, whether it's MCM, UHG, Crown Asset, they all have the same crap. A lot of them, LVNV uses Lynn Fisher to state all this stuff that isn't true, in my opinion, and the documents. So this is what you must learn from this video, okay? The number one, according to the loan agreement, there's only one creditor, that's FinWise Bank. So that's in your form. Number two, there's no proof of an assignment of anything getting sent to FinWise Bank, to Upstart Structured Pass-Through Trust. Nothing from FinWise. And in fact, the Upstart Structured Pass-Through Trust Series 2022-1A isn't in the loan agreement. So they can't be a creditor if, God forbid, you could have both in and both be creditors. They'd have to be in the loan agreement. It's as simple as that. So there's no creditors. Thirdly, a creditor is an original creditor. The next creditor is the current creditor. It's a term of art that is used in the law. You can't bend around that. There's no creditors. So paragraph 9 is false on many levels, and you're providing the court, if you can keep it to one page, I'm going to show you how I did it in my answer. You'll be fine, because you put it right at the front, because let's take it. Let's be honest. Judges are either busy or lazy. You pick it. And you've got to put it right in front of them, because otherwise you're just another collection case complaining. So put it right in front of them with this form. It's also almost appellate proof. Like, it's a lot of judges go, well, I didn't see anything. Here it is. What didn't you see? Look for the loan agreement and how it could be signed in 2021 and no activity on it prior to November 23rd, 2022. In other words, there's nothing between those 2 points, regardless of what they say with this bill of sale. Nothing showing what was transferred to FinWise. But more importantly, and you did not see this, you did not see specifics in paragraph 9, there's nothing there that says Velocity received it from the only owner at this point, Upstart Network Inc., after November 23rd. There's nothing in that complaint. That goes into your counter affidavit. That goes into your new form I'm introducing you. So there's also a little thing called a choice of law. In the loan agreement, Cindy put the governing law up. Shazam. See that? 16, governing law. By the way, you're almost at your bonus point. I'm going to give you a great thing. It's just going to... I love to piss them off and to be a pest. This will do it. Using their own forms against them. So number 16, the governing law provision that's in the contract. So quickly, if you have a contract, you're being accused of breaching the contract. The contract in this case says you got to bring this in Utah. In this case, this one's in Michigan. So they just breach their own terms and conditions, and they're saying, hey, well, you got to have clean hands to point the finger at someone. And when you point the finger at someone anyway, there's 3 more coming back at you. So they're a whole plate of wrong. So here's your bonus. Look at in their loan agreement. I'll just give you a section. Section 13, Cindy. That's called the registration. And in that, if you can blow it up so the fine folks can read this, Cindy, it says, you want to know who owns this debt? Who was assigned? How we assigned? Who has it now? Write this address. So I did. I got a letter for you attached to this video at my membership website, collectionstoppersolutions.com. All ready to go for it. It's even got Upstate. It even got Upstart's address. Well, you're going to find that in most FinWise, Upstart, Cross River, Blue River loan agreements. So just act accordingly. Just fill in all your facts. And I cut and paste that section and put it right in the letter for you. If that was your loan agreement, you just cut and paste their loan agreement and take that section, whatever it is, and put it right. And by the way, they're really crafty. A lot of times you send a letter, they'll go, oh, you want validation? Here's validation, even though you don't say validation. So you'll see my letter. I've got it specific to what I want, the loan number. There's no, I don't want validation. I want you to do what you, and I put right in the letter, you invited me to write to you for an assignment. Can you please honor that invitation in paragraph 13? Here's paragraph 13. So that's a beautiful thing. That's a bonus letter for you, okay? All of that goes into your counter affidavit, which jumps into your answer, which jumps into your affirmative defenses. And again, I'm going to add the answer to this video. Look at the front of my answer. It's in Word, so you can take your rules, your facts, your law, and put it in and make it your own. I put that form, the broken chain of title form, right at the front. The judge has no excuse, because he or she does try to wiggle out of this and say, well, I don't see it, boom, right in front of you. So you got the counter affidavit. And in fact, that form I give you, as you can see, I have Exhibit 1, Exhibit 2, Exhibit 3. There's no wiggle room. You can show the court. Just the dates alone. They said they sent it the 17th. Well, the original credit didn't send anything until the 23rd. Case closed. But you got to put it in front of them because they're always gunning against you, right? So the conclusion here is there's only one creditor, and that's FinWise Bank. Upstart has not, though it received it November 23, it did not give it to anybody. So whoever's suing you has no standing. And those are the words you use. I go crazy, and I put up the owner, the guy that signed this. He signs all these. Sanjay Datta, the CFO of Upstart, he's on everything. I immediately start deposing him. That case gets settled. So on my membership site will be Word form documents, chain of title form, that new thing I'm sending you today, the counter affidavit, the answer and affirmative defenses in Word to conform to your needs, the counterclaim. You know what I did? I filed a counterclaim based on all of this, and that's the basis of a counterclaim. Because if you've got enough to answer and go, what are you kidding me? You've got enough to go on the offensive. So that's in Word if you want to use it. And that bonus letter to Upstart for the assignment proof in Word is on and attached to this memo. So you got a ton of stuff, plus my show notes. So if you don't want to look at this face again, you can just look at my show notes, which are spread around like I memorized this whole thing, which I normally do, but I literally just had a member chat to me and said, can you do this blah, blah, blah video? I'll do it right now. So I'm doing it. So I didn't memorize it, but I did write it for you. They're in my show notes. I hope that helps you break down their chain of title. I hope the camera wasn't too weird. It's a new camera and a new plate. I just did it right at my desk. And let's rock and roll. Let's go get these guys. They shouldn't get away with this. Judges shouldn't get away with this because they look the other way. Well, put it right in your face. Remember, put it at the front. You know what? I'm also going to attach the answer, the actual answer and affirmative defenses that I filed against these guys. And you can see in my actual answer to the court, got it right at the front page, so he or she can't avoid it. By the way, when you send in your answer, put a sticky note, a pink sticky note, right where you want them to look. They can't. I've had that appeals where they go, well, I didn't see anything. So I tell the Court of Appeals, he or she did not see anything. This is what I gave them. What is it they're saying they didn't see? That's 30 years of dealing with people. Hello, it's right in front of you, and they pretend they don't see it. So you just have to do more. We have to lift 100 pounds while they're lifting 10, but it'll pay off, trust me. Use this stuff, and you'll win, you'll settle, and you go get those guys. Thank you very much for your time.